Hi, this is the Philosophical Angle program, and I'm your host, Chris Angle. I'm the author of 4 books on philosophy, one of which is the Defining Ethics, Good and Evil, and these books are available free for viewing at thephilosophicalанgle.com. If you'd like to make comment, you can contact us at contact@thephilosophicalанgle.com. Along with me is my colleague and co-host, Rick Samuelson, and Rick graduated from Yale and has MBAs from Wharton and Tufts, and he's an independent venture capitalist. And good to see you, Rick.
And you. Merry Christmas.
And the purpose of the Philosophical Angle is to examine the nature of concepts and ideas in current media. And so this week we're going to discuss the Supreme Court deciding to refuse to look at the Texas case, where it sued 4 or 5 states over the election, and the Supreme Court said that they had no standing and they didn't want to take a look at it. Even though scores of states, well, actually I guess it was like 18, submitted supportive material, and 106 GOP members of Congress were on the side of the Texas suit, and so there's it was a considerable a case of moment and importance. And even though the Supreme Court is the natural venue of problems between the states, and especially of very important issues, they still they refused it. And it actually said, and I'm going to quote here, Texas has not demonstrated, the Supreme Court said this, Texas has not demonstrated a judiciary cognizable interest in the manner in which another state conducts its elections. There were 2 dissents. Justices Thomas and Alito dissented, and they stated that the court does not have discretion to deny the filing of a bill of complaint in a case that falls within our original jurisdiction. And so they're saying that it's the obligation of the Supreme Court to take this suit, because arguments between the states naturally fall within the jurisdiction of the Supreme Court. So why the rejection? Why did this happen? Obviously, the Supreme Court, the majority said, well, it has no standing. So that's the ostensibly that's the reason, but it's kind of difficult to believe. There's so much at stake at all levels, and one taking a look at this, you'd kind of say that Alito and Thomas were correct. It's obviously there's no other place to put it, and it's an obligation by the Supreme Court to take it. And so what is this? It's you kind of fall back and kind of think, well, it's intellectual cowardice, and they are worried about the consequences. They're worried about the riots, perhaps, and harm to the nation, and they're worried about possibly they're worried about their own physical well-being. They know what the left can do, and its history of violence, and they've been perhaps influenced by the violence of the left. And all you have to do is look at the history of the left and to know that they are capable of great violence. You just have to look at the history of all the great left leaders, such as Stalin and such as Pol Pot and Mao and Hitler. And yeah, I know some people would say, well, Hitler's of the right, but actually the word Nazi actually means the Nationalist Party. the National Socialist Party. And so you kind of come to the conclusion that, in all respects, that the Supreme Court is they're cowardice. They're cowards here in not being able to take this this lawsuit. So, we can make a little fun of this and say that their action would not be a good example of Jack Kennedy's book, Profiles in Courage. So, are there any other consequences we could come to any conclusion about this? And I think that there is. I think that we can conclude that they knew that if they took the case, they knew what their conclusion would already be, and that they would have to side on the side of the plaintiffs, but they wouldn't want to, because they think that the violence of the left is probably has intimidated them, and so it's best that they decide it's best that they don't take the case up front, because the specious reasoning to just deny standing is a lot easier to make than specious reasoning that would be employed if they had to make a conclusion on the final briefs that they would have to determine their conclusion about the case. So really, we can only conclude that they're just afraid of the left, and that's why they did what they did. And so let's ask Rick to see what he thinks of all this.
Well, I'm a great fan of Justices Alito and Thomas, and I tend to think that they are right on most legal principles. I guess, I take your point that this was very narrowly decided, and I suspect in the background there's a fear that it would lead to a series of cases where one state or a group of states are suing other states for all manner of reasons, and and while that is obviously a risk, clearly the fact that the voting standards across the states vary, the methods vary, the reliability of those standards varies, and the fact that there were measures taken late in the game, under the pandemic craze, if you will, to alter the normal procedures. I think they could have carved out this as a special case, given that background. I also think that you're right. The reaction of the left would have been violent, and is that a legitimate concern? Probably. Is it violence on the scale of the Civil War? Most certainly not. So, there's violence and then there's violence. So I think those are the kind of risks you have to take when, major principles are at stake. I mean, that's the risk that the Union took, or that's the risk that the Confederacy took when it bombed Fort Sumter, right?
Right.
Because what followed thereafter was basically a foregone conclusion that there would be violence, and it was settled 6 or 7 or 800,000 lives later.
Right. So you have to weigh the principle versus the sacrifice of the nation.
Well, I mentioned that because there was a case where it was the greatest war by far in the history of our country. Many people died, many more were injured, and compared to what might happen, left in reaction to any Supreme Court decision. I mean, it's orders of magnitude greater. So I don't particularly fear the left in that regard.
Right. The sacrifice that they would make to create violence is nowhere near what the history of the United States has already endured. So I agree with you. Yeah, that's a good point. Any final thoughts here before we conclude?
I think it would have been useful to even if they decided against Texas and the other states, the evidence that would have been brought to bear and brought to light on the workings in these various jurisdictions and various states would have been extremely informative for the voter. And it would have been a clarion call to clean up the systems in the respective states.
That's a good point. So on that dimension also, they failed in allowing all this to come forward, and so yeah, it's a total failure on the part of the Supreme Court. Rick, thanks for.
That should have been a unanimous decision, right?
That's right.
It wasn't.
Either way, it should have been unanimous because of its import and because of its importance to the nation. Okay, thanks for your comments, and we'll see everybody next time on The Philosophical Angle.